Second case this morning is Brian, I don't know if it's NIES versus Affluent Funding. Counsel, whenever you're ready, you may proceed.
Thank you, Your Honor. May it please the court? My name is Jim Ippoliti, and I'm here with co-counsel Scott Wiederman from Wiederman Malik on behalf of the plaintiff appellant, in this case, Brian NIES. And I'd like to reserve 5 minutes for rebuttal. It's a unique case because we've got a vehicle here that is a non-street legal race car that races exclusively on racetracks like Daytona Speedway here. It is uncontested that this is never driven on the streets of Florida, nor could it. No headlights. It's five-point harnesses, things that are exclusive to race cars that are not street legal. It's our position that there's 3 issues that we need to address within the appeal. One is the ownership interest in that race car. The second is the statutory inapplicability of the motor vehicle statutes, Florida Statutes Chapters 319 and 320. And then also the actual notice that was provided to the defendant appellee in this case. We'll start with the ownership of the race car.
Just for clarity, I'd like to jump ahead just briefly and ask you, what are you seeking as a remedy on appeal?
The remedy that we're seeking, Your Honor, is a determination that the Florida Statutes Chapters 319 and 320 are inapplicable. The ruling of the court, in the trial court, was completely based on you can't establish ownership because these statutes apply, and because these statutes apply, we need to have a title.
Okay, so if we find that 319 and 320 are not applicable, then what is the direction that you're seeking for us to provide?
I think that I'm sorry, Your Honor. The findings of the trial court will satisfy the requirements of what we saw and I believe it was our count 1 of conversion. The court found that the other elements were satisfied. Specifically, I can read through those if you'd like. But it gets hung up on the issue of ownership. That's in the final judgment?
In the final judgment, the court found clearly that the elements of conversion were not satisfied?
Trial court found, on or about February 4, 2011, did plaintiff purchase a 1/2 ownership interest in a Ferrari from William Payday? Yes, plaintiff purchased 50% of the William Payday's interest in the Ferrari. Was a Ferrari purchase memorialized in writing in a bill of sale to include the vehicle by both description and vehicle identification number and price? Yes. Did the pledge of the Ferrari as collateral in the affluent loan negate any ownership interest plaintiff had in the Ferrari? No. Did affluent exercise a positive, overt action of dominion or authority over plaintiff's interest in the Ferrari, which was inconsistent with and adverse to the claimed rights of plaintiff? Yes, over plaintiff's claimed interest. On or about February 16, 2016, did affluent unilaterally sell the Ferrari without notifying plaintiff or this court? Yes. Was plaintiff without knowledge of the sale of the Ferrari by defendant affluent, did not authorize such a sale, and did not receive any compensation from this claimed share in said vehicle? Yes. What was the value of the Ferrari at the time it was sold by affluent? $180,000. The required elements in the 5th District for conversion include defendant's unauthorized act that deprives plaintiff of his or her property permanently or for an indefinite time, and the deprivation is inconsistent with plaintiff's ownership interest in the property. So it's our position that all of those requirements have been satisfied. The court was hung up on trying to fit this case into a statutory box, and it simply can't be, and I'd like to discuss those statutes. The ownership issue is very clear. We have a case where WP Jewelry, not a party to this lawsuit, signed a security agreement with the defendant. WP Jewelry, within a security agreement, pledged a Ferrari. Well, the record is clear, WP Jewelry owned no Ferrari. The Ferrari is owned by William Payday. So the security agreement is out of play in this case because it doesn't create any rights, because they don't own a Ferrari. Where Mr. Payday comes in is he signed a personal guarantee. However, Mr. Payday never had a lawsuit against him. He's not a judgment creditor. He's not a debtor. There was no writ of possession, nothing. It was self-help only on a form of defendant. Defendant came in and took William Payday's vehicle based upon a breach of contract by WP Jewelry. WP Jewelry is a multi-member LLC in Florida. He was not the only member, and that is uncontested in what is stipulated facts. And the court found throughout the final judgment that Mr. Payday sold 50% of the vehicle to Mr. NIES. It was memorialized in the bill of sale. That Affluent did not perfect its security interest in the vehicle. That William Payday he had the right to pledge the vehicle, but only as to the amount that he owned. And the trial court correctly found that Mr. Payday owned 50% of the vehicle. Mr. NIES owned the other 50%. So Mr. Payday was more than willing and more than able to collateralize his 50% interest, but that's all he owned. And did the pledge of the Ferrari as collateral in the Affluent loan negate any ownership interest plaintiff had in the Ferrari? No. It's our position that a bill of sale acts much like a quitclaim deed in real estate. It is effective upon execution. The title creates notice to the world. That would be the recording of the deed. In this particular case, we have actual notice. We sued the defendant before they sold the vehicle. Not only did we put 2 registered letters that we sent to them letting them know we want equal possession, equal rights to this vehicle, then we sued them and we served them. And what did they do? 7 days after being served, they did a fire sale without advertising, sold the vehicle to someone on the California coast to try to get rid of it. The court has deemed that the vehicle was worth $180,000. It was sold for $52,000. So it was clearly done to try to, let's get rid of this vehicle. But they didn't have a right to sell our client's half. It's our position that they didn't have a right to sell Mr. Payday's half either. There was no adjudication of wrongdoing by Mr. Payday. WP Jewelry is its own case, but they don't have a judgment against WP Jewelry either. So they just used self-help against a personal guarantee. So it's impossible for Mr. Payday to collateralize more than he owned. If I own a share of Disney stock, I can't go collateralize all of Walt Disney World. I can only use that one share, much like Mr. Payday's interest. He can only use 50%. That's all he owned. So the court relied on these Florida statutes because they needed to get this in this box of motor vehicle statutes. The problem is it can't fit in this box. Motor vehicle statutes are designed for cars that are driven on the streets. They provide notice to the world. So if you hit somebody or you speed or you go through a toll, they can find that vehicle and find out who it is. But let's look at these statutes individually. The only statute that was ever discussed in this case was statute 319.27. That's it. And it was never brought up by either party. It was never brought up as an affirmative defense. It was the judge himself who asked at the end of the trial, I want you to brief the issue of 319.27, whether it would be applicable. And there was no objection to that. Both parties detailed briefed that statute. We said, here's each of the subsections of 319.27, and none of them apply. In the closing brief, filed subsequent by the defendant, agreed. 319.27, inapplicable in this case. That's it. There is not one discussion of any other statute in 319 chapter or chapter 320 that is any way related to this case was never brought up. Instead, what happened, we've got the trial judge that became an advocate for the party, interjected statutes that were never discussed, interject statutes that we never had an opportunity to present evidence to. There's no evidence in the record whatsoever that any other discussion other than 319.27 ever occurred. So it would be improper for the judge to then base his entire final judgment on the applicability of statutes other than 319.27. And again, 319.27 was brought up by the judge himself. It was not brought up by either party, was not brought up in an affirmative defense. But let's look at these statutes. 319.27, both the parties agreed, does not apply. 319.20 is the important one. And I'm going to read it. It's titled Application of Law, and it expressly states, except as otherwise specifically provided, this chapter, chapter 319, applies exclusively to motor vehicles and motorhomes required to be registered and licensed under the laws of the state. Registered and licensed. Well, the trial court expressly found in its trial findings that the evidence established that the motor vehicle was not street legal at all times since 2006, and that the Ferrari was not used on the streets or highways of Florida. Therefore, the Ferrari was not required to be registered in the state of Florida.
Okay, first question. Was it a motor vehicle?
Well, by definition here, I would say no. The court relied on they looked over to chapter 320.01, and they said, well, the term motor vehicle means an automobile, motorcycle, truck, trailer, semi-trailer, truck trailer, and semi-trailer combination, or any other vehicle operated on the roads of this state used to transport persons or property and propelled by power other than muscular power, but the term does not include traction engines, road rollers, such vehicles as open only on a track, bicycle, or moped.
So based upon that reading, is the Ferrari an automobile?
Our reading of it, absolutely not, because it specifically says, or any other vehicle operated on the roads of the state. It's very clear that the trial court found that it was not operated on the roads of the state. But let's look at the statute as a whole. Chapter 320 of the Department of Motor Vehicles, that's for licensing. It has nothing to do with ownership, has nothing to do with titling. It's specific only to licensing. Let's look at some of the race cars that have raced around Daytona. Richard Petty, Martin Truex. Are those motor vehicles? Because if this statute would apply, if all vehicles are motor vehicles, then they need to be titled. They're not titled. They don't have
Let's say
titles.
it is a motor vehicle. Let's say we assume that. Is there still another provision that would not require it to be licensed?
Absolutely. We're going to go right back to 319.20. This chapter, which is the ownerships, this is the titling section. This is the applicable one, chapter 319. This chapter applies exclusively to motor vehicles and motorhomes required to be registered and licensed under the laws of this state. So even if you assumed it's a motor vehicle, which we do not, we think it is absolutely not a motor vehicle, even if you assume that it was, to answer your question, it is the trial court's finding that this vehicle did not need to be registered. 319.20 says in order for this entire chapter to apply, that vehicle has to be registered and licensed under the laws of Florida. So there's your out. It doesn't apply. That statute is directly on point, cannot be misconstrued, couldn't be more clear. It doesn't apply. The entire chapter of 319. So if 319 doesn't apply, all of the court's findings that, well, you didn't prove ownership, everything else is in play, but you didn't do a title transfer of this race car, so therefore you didn't prove ownership. So all the other things are we have to look away from. The court found that our client owns 50% of this race car, yet allowed the defendant to go and sell what he didn't own, what they didn't own. It's an entity. That's where we have a problem here. These statutes don't apply, and the court tried to force them into that statute box that simply did not apply. Let's go to the issue of title, because again, title provides notice to the world of who owns this vehicle, so someone can search and look for it. This vehicle was owned by three individuals. Initially, Aaron White. Aaron White sold it to William Payday. William Payday sold half interest to Brian NIES. All individuals, never owned by an entity. There would never be a UCC1 filed, for instance, because these are private owner vehicles, okay? So what we've got is a bill of sale. If you've ever watched TV, watched the Mecum auction, you watch the Barrett-Jackson auction, if you do a simple Google search, you're going to come up that race cars are typically sold on bill of sale. The testimony, uncontested at the trial, from including our expert witness, including the former counsel for the defendant, admitted, yeah, these vehicles are sold typically with a bill of sale. Why? because you can't have a title because they're not street legal. You can't register them. If you took and tried to register Dale Earnhardt's stock car at the DMV, they'd send you right back out the door. It can't happen. So with this particular case, how do we provide notice? Well, how would they have notice? Very simple. We sued them. We served them with a complaint that said, we own half of this vehicle. Here's the bill of sale that shows we own half of this vehicle. We gave them actual notice. Notice to the world. We gave notice to the person who was most important, the defendant. And what did they do with that notice? They sold the vehicle. They sold it in a fire sale for less than 20% of what it was worth to someone in California in a hidden sale. And what did they do with those proceeds? Did they take them and put them in the coffers of the court and say, court, we sold this vehicle, please determine who gets the money? Did they take half of the money and put it in?
Do you think that establishes criminal intent?
It was our position at trial, yes. The trial court found no. And it's our position that is a discretionary finding, and it would not be appropriate for an appeal. So we are here strictly on the conversion, not the criminal intent. But yes, we believe it was. How can the criminal intent was clear? They sold something that they knew had actual notice that they didn't have a right to sell.
You're about a minute into your rebuttal time, just so you know.
I would like to reserve if there's no further questions at this point. Thank you.
May it please the court. Eric Reed on behalf of Affluent Funding, the appellee in this case, and the defendant in the lower court. The big question that we've heard is who owns this vehicle? And that's really what the trial court...
Actually, Mr. Reed, before we
Yes.
get to that point, was there any evidence presented to the trial court that this vehicle was ever driven or operated on the roads of the state of Florida, public roads?
There was discussion about it being brought to some fairs and celebration. Was it actually driven on the roads to get there? It was housed in, their testimony was housed in celebration at Mr. NIES's house. Did he trailer it to the events and the festivals? They did trailer it to the racetracks. There was record evidence of that. Did he drive it around? Did Mr. Payday drive it around? I don't know. There was no testimony of that.
So at best, undetermined, correct?
Correct.
Okay.
Thank you, Judge. So the big question was the ownership. Who owns this vehicle? We've heard a lot about the bill of sale. We heard a lot about the bill of sale in the trial. The bill of sale, the testimony from the witness was that the bill of sale
Is the bill of sale in any way deficient as far as documenting the sale of the vehicle?
Correct. It's the Affluent's position. It was deficient. It did not include various items that would be required in a bill of sale. Witnesses, notaries, full names, contact information, what you would typically see on a bill of sale if you were transferring an interest or half of an interest, in this case, to a vehicle. But it's not just the bill of sale issue in terms of ownership. It was various other items that were not proved at trial as to what Mr. NIES's, did he own this vehicle? And that included proof of payment. Big discussion about, hey, I paid $30,000 cash. Do you have bank records? What can you prove to this court that you actually paid $30,000, that you had consideration and you own half interest in that vehicle? The only testimony was Mr. NIES saying, hey, I paid cash, $30,000. Was there any proof of insurance? No, from Mr. NIES. Was there any proof of maintenance records, any proof of insurance, any proof of sales, paying a sales tax for his purchase of 1/2 interest in his vehicle? None of that was found by the trial court. And when the trial court entered the order, it said, did Affluent violate statute 772.11 when it sold the vehicle? Answer, no. Did Affluent act with criminal intent? No. Is plaintiff entitled to damage? No. But the bigger piece of that is,
Did Affluent have notice prior to selling the vehicle?
Affluent did have notice. That is, and counsel brought that up, that is not an issue, and Judge, you mentioned this, what's on appeal? And that's, I pulled up the statement of issues from the appellant, and it deals with, there are 6 of them, 319, 320, 319, I'm talking about the statutes. The Wood case of who made the loss, 319, and whether a bill of sale and ownership. There's no issue on appeal as to notices provided. But yes, to answer your question, absolutely, notice was provided to Affluent.
Do you have, counsel, do you have any authority that testimony regarding the amount paid would not be sufficient to establish that? Is there anything that says definitively you need documentary evidence other than just the testimony? Because didn't both parties testify that there was a $30,000 cash payment?
There was testimony of just Mr. NIES. Mr. Payday, there might have been a reference in the appellant's brief that Mr. Payday did not testify at trial, but his deposition was taken as well. And in that deposition, he said that he did receive $30,000. But in terms of proof to substantiate at the trial, there was nothing that supported that, no documentation, anything like that. It was cash payment.
And you're not saying there was inadequate consideration. The bill of sale specifically identifies the car, provides the VIN number. So that's what Mr. Payday is providing, and Mr. NIES in the bill of sale specifically says for the sum of $30,000.
Correct.
So
Yeah, that's exactly what the bill of sale says. And again, we show some deficiency in the bill of sale, along with what was not proven at trial, what was not, the evidence was not there, and that's when the court ruled, did the plaintiff prove elements of conversion and civil theft? No. The court did go on after with additional findings in the trial order and mentioned the 319 and the 320 that a substantial amount of time was spent on in both briefs. And those, and we probably would both agree that those really don't apply to our situation. Is who owned this vehicle? And the trial court determined that Mr. Payday Mr. NIES could not prove ownership of the vehicle, and more importantly, that the elements of conversion and civil theft were not met, and therefore the court ruled.
And entirely, it was the inability to prove ownership of the vehicle was tied to the application of Florida statutes 319 and 320, correct?
Correct.
So if we find that the appellant wasn't required to obtain title to comply with Florida statute 319, then who's responsible for the loss in this case?
The loss would be responsible to the appellant. If the court finds that Mr. NIES was required to obtain title to put everyone on notice.
No, that's not my question.
Sorry,
my question was if we find that he wasn't required to comply with Florida statute 319, who is responsible for the loss in this case?
Well, Your Honor, I believe it would still be really Mr. Payday, who's not a party, but the appellant. Again, that's just one element. If one of the elements is they were required to obtain title and the court finds no, they were not. Well, the other elements were, well, what other proof of ownership can be shown? And that's what.
But Mr. Payday wasn't the one who, when they received notice, decided to disregard the notice and sell the vehicle. That would be your client, correct?
Correct. Yeah.
Did Mr. Payday receive notice of claim at all?
I'm not aware if Mr. Payday received notice of the claim. He was deposed in the case, so he knew about the case. But in terms of the notice, I'm not certain if Mr. Payday was provided that notice.
Was Mr. Payday aware that there was a sale that was made despite there being no notification to the court or to Mr. NIES?
I'm not sure if Mr. Payday was aware of that.
Okay.
Yes, Your Honor.
Was there anything in the court's order that indicated, other than his consideration of 319 and 320, that he didn't find they had proven ownership? Clearly, he was saying that's the reason I'm finding there's no ownership. Was there anything else in the trial court's final judgment that referenced this issue?
Other than in the I guess it would have been the trial order and then the judgment entered thereafter, importantly, that the proof that conversion elements weren't met and civil theft, all in one with the various elements that the court found that those weren't proved. When we still get to, and we recite at the end of our brief, the tipsy coachman doctrine, the court still got to the same, maybe using different rationale and reasoning, came to the same result, that the appellant failed to satisfy the burden of ownership of the vehicle. The bill of sale obviously is critical with the deficiencies in that, and the evidence that wasn't presented to the court regarding, well, what all did Mr. NIES prove to the court that he did have an ownership interest in this vehicle. And that's what they failed to prove, and therefore the court ruled in favor of Affluent that they were not found that there was any conversion or civil theft, and the court didn't even have the ability to rule as to declaratory judgment as to, really who owns this vehicle based on the trial order.
What are you pointing to as the deficiencies in the bill of sale?
Sure, Your Honor. The deficiencies included it was not notarized, not witnessed, did not contain the contact information of the parties. The signature of Mr. Payday was different than what was signed. And those are I believe, the 4 deficiencies in the bill of sale.
But Mr. Payday testified in his deposition that he did transfer ownership for $30,000, half.
He testified that he received $30,000. His testimony as to the bill of sale was, I don't recall the bill of sale. There was a whole discussion of, well, who prepared this? And he's like, well, I don't really recall that document. I'm not sure. And Your Honor, on the appellate issue, the notices, as I mentioned, are not part of the appeal, and the appellee Affluent will request that this court affirm the decision of the trial court, and if there's any other questions, happy to answer those.
Okay, thank you.
Thank you.
Thank you, Your Honors. Just a few clarification points. You had asked an earlier question of what we are seeking today. The damages that we seek are 50% of the value of the vehicle at the time it was sold. It was $180,000, so we're looking for $90,000 plus statutory interest from that date forward. We heard about the bill of sale, deficient bill of sale, deficient bill of sale. You had a great question. Why is it deficient? There was no statute discussed. There was no case law discussed saying that there needs to be witnesses and notary. They weren't discussed because they don't exist. A bill of sale describes the vehicle, describes who bought, who sold, how much it was for, and was signed by both parties. The 2006 bill of sale that defendant relied upon, that was from Aaron White to William Payday, was nearly identical. The one that they based their self-help repossession of the vehicle was based on an identical bill of sale. Also not witnessed, not notarized, all the things that are hypocritically being said are deficient in this bill of sale. Payday acknowledged that, although he says, I don't remember this document in particular, it was 7 years ago, but what he said was, yes, those are the terms I agreed to, and yes, that's my signature. He said, well, there's no testimony to show that $30,000 was paid. Well, the testimony of William Payday, which was in a deposition, but that deposition was admitted into the record. So that was before the court. So the testimony of William Payday, I received $30,000. The testimony of Brian NIES, I paid $30,000. The bill of sale, documented, signed, hard documented evidence, $30,000 exchanged hands. So to say that, well, we're not sure this $30,000 ever exchanged hands is not proper. Tipsy Coachman, if you read through the final judgment, it is very clear that the trial court relied on every finding of ownership specific to statutory 319 and 320. Absolutely 100%. In fact, when he references the Tipsy Coachman, he actually even referenced under Chapter 319. There was no alternate factual finding that can support a claim that a vehicle title was required to prove ownership of a race car. It doesn't exist. The trial court already correctly found that William Payday owned or sold 50% of the race car to Brian NIES. Also found that the defendant exercised a positive, overt act of dominion or authority over plaintiff's interest in the Ferrari, which is inconsistent with and adverse to the claims of right of the plaintiff. Also found that any pledge would not have negated the interest that Mr. NIES had in the vehicle. Affluent could not sell more than they owned. defendant in their brief says, well, this car is incapable of being divided in half, so therefore we sold the whole thing. That's not the way it works. It is capable of being divided in half. It's a dollar value vehicle. They could have come before the court and said, we want to sell it. No different than a partition of real estate. We want to sell the vehicle. We're going to find the best, highest price person that's willing to buy it, and we'll let the court determine how we're going to divvy up those funds. But that's not what happened here. What happened here is they sold it on their own. So Tipsy Coachman is not supported. There is no factual record before the court. Nothing. No finding of evidence that would support that a title was required to prove ownership. So if you wipe out the statute, if you wipe out the ownership, what we're left with is Mr. NIES owning half of the car, providing proper notice before the sale, and therefore entitlement to half of the value, $180,000 plus statutory interest. Our time is up. Thank you very much for your time.
Okay, thank you, gentlemen.